Yes, I'm Baroness Kidron. I'm a crossbench peer in the House of Lords. I'm also the founder of Five Rights Foundation that works at the intersection of childhood and technology. I'm an advisor to the Institute of AI Ethics at Oxford University and a member of the UN Broadband Commission for the Sustainable Development Goals.
Could you please describe your educational background and your qualifications?
Yeah, I was, for the first 30 years of my professional life, a filmmaker, film director, but since 2012, when I was appointed to the House of Lords, I've been instrumental in the creation of data protection legislation, online safety legislation, and involved in digital competition legislation. And in particular, I am credited with the age-appropriate design code that introduced a higher bar of data protection for children under the age of 18 that was brought into UK law in 2018, but has been mirrored around the world and adopted very broadly. Oh, I also chaired the drafting group of the General Comment 25 on the relevance of children's rights to the digital environment.
Could you explain any specialized knowledge that you have regarding social media platforms and their impact?
I think that my last decade and a bit has given me a very broad understanding of how digital technologies affect society, and in particular children, i.e. those under the age of 18. And in the course of my work, I regularly speak to engineers, computer scientists, technology businesses, as well as the enforcement community, regulators, governments, parents, and indeed children themselves.
Thank you. And have you published any peer-reviewed articles or other scholarly works?
Yes, I've co-authored a number of reports under the auspices of the Digital Futures for Children Centre at the LSE, which is a LSE Five Rights research group. I have also published a number of reports, both in my capacity at the UN Broadband Commission, on committees at the House of Lords, and I would say that although not peer-reviewed, Five Rights has published a number of reports that are widely cited and have been hugely impactful on research around the globe, including introducing new methodologies.
Thank you. And have you testified before legislative or judicial bodies on these matters before?
Yes, I have. I have testified for Congress, for the states of California and Maryland, for the UK Parliament, and in the EU, and of course at the UN Committee of the Rights of the Child.
With that, Your Honors, I would like to offer Baroness Kidron's testimony today as an expert.
Is there any objection? No objection. She is so qualified.
Thank you.
In your expert opinion, do the rights of freedom of expression under Article 19 of the ICCPR and Article 10 of the ECHR extend to social media platforms?
Categorically, yes. Those rights were designed to protect expression, through any media. And in fact, the language that the drafters used was deliberately tech neutral. And social media have become the primary channels for seeking, receiving, imparting information. So yes, those rights extend to social media companies.
And are you aware of any international bodies that have interpreted these rights with respect to digital media or the internet companies?
Absolutely. I mean, there are multiple UN resolutions and general comments, And indeed, General Comment 25 for the CRC was explicitly commissioned to make clear that children's rights apply in the digital world, and also the Court of Human Rights has similarly recognised social media as protected forms of expression in several landmark cases.
Thank you. And based on your research and work in the field, are you aware of how social media platforms' algorithmic systems interfere with the rights?
Yeah, I think it's very well documented that algorithmic systems are designed to maximize engagement, time spent, and spread. And that weighting, in effect, editorializes or puts one piece of information above another. And in particular, as we've already heard, that they amplify emotional, divisive, misinformation, and they effectively create what I would call an unstable information environment. And I think that it's important in this conversation at the earliest point to say that these represent corporate priorities, not democratic priorities or human rights priorities as we have set them out, but corporate priorities that could be commercial and in some cases could indeed be ideological.
Are there any specific examples that you've worked on during your career that you could talk about, for example, Brexit or COVID-19 pandemic related issues?
Yeah, I would, but maybe I could first go to a very, very detailed example, because I think it's well established that both during the pandemic the misinformation was rife and actually cost people's lives. And indeed, we saw that Brexit brought a new form of targeting against particular groups that were seen to be more aligned with particular views. But the example I'd like to give the court is actually in a 2021 piece of research where Five Rights developed avatars as a proxy for individual children. And within 24 hours, all the boys had been sent pornography and invitations for sexual activity, but none of the girls were. And I think that that's a very clear example of how the information environment is simply not acting in a neutral fashion.
So, I agree. So, in your opinion, how would that affect a consumer's ability to interact or obtain information or to impart information of their choice?
I think this idea of both user and consumer needs a little bit of interrogation. I mean, I was very struck in the opening statement by the defense of this idea that media has always been rich men getting into the bedrooms of poor people. And it is indeed a very good song. However, I think that there was a sort of a slight sense in that testimony that because things have been bad, we should accept worse. And so I think what I'd like to say is that actually it's the concentration of power, it's the concentration of media that represents the most problematic aspect of it, not for the consumer, not for the user, but for the citizen. And it's as a citizen that you need to have information that is truly in the hands of many, truly interactive. And if it is the case, and it is the case currently, that algorithms serve information either for the purposes of sort of expanding the network, i.e. the most emotive, most divisive, most extreme, or more importantly, in my view, prioritizing for money. And remember, for example, the X, the blue tick on X, you can buy, and then you are your material goes further, faster, is given higher priority. So if you can buy this, or if it is deliberately explosive for commercial reasons, then actually the citizen is not getting a fair or even chance, and voices are actually subdued.
So in your opinion then, the algorithmic amplification or the design of these social media platforms, is it attributable to their choice, the social media platform's choice?
Well, yeah, I mean, absolutely. I think that we heard earlier about decisions to downplay news in the user feed and upplay friends and family. I always think that Mark Zuckerberg's statement and that a squirrel dying in front of your house may be more relevant to your interests right now than people dying in Africa, sort of was a moment of understanding of what the motivation of a social media company is versus, the needs of a citizenship. And I think this idea that we all get the information we need is very disorientating. And as I work a lot with children in particular, I think it is, you can see the results of that in that they trust, increasingly they trust a bot friend more than a friend. And they trust what Google says more than any other adult, and certainly more than the news. And so we have a situation where it is determined by corporate priorities. It is based on spread engagement and basically trouble, if you like, yeah? And I think it's important to say that as voices get amplified, that does mean other things get downgraded. And we've seen that very explicitly in the news, and maybe we'll come on to it when we talk about particular groups of users.
Now, with your work with the House of Lords and your knowledge of other international organizations' hearings, are you aware if the platforms have acknowledged any of these issues before legislative bodies?
Yeah, I mean, that's a very interesting question. I think acknowledged, should we say, reluctantly and partially. They have acknowledged, and I would say this: we are not living in an equitable information system, so they have not mitigated anything that they have acknowledged. And I think that they are pursuing a view that it is the users and not they who determine the outcome of their services. And I strongly, for the reasons I've already given, I would strongly contest that. And I think, it's important to think about the fact that almost every whistleblower, and indeed, I have the privilege of doing this for some time, so I have a couple of people within the industry who regularly speak to me. They all talk about the fact that the metrics for addressing harms are of a lower priority than the metrics of engagement, spread, and growth.
And aside from the ad revenue justification, are you aware of any legitimate justifications for interfering with an individual or citizen's ability to receive and impart information?
I think that at a state level, there are sometimes reasons to to interfere. But if you are asking specifically, do I think that the social media companies have the right to interfere for their own purposes? I think that's a more complex question, because their denial that they're interfering pulls a cloak over the reasons for why they are interfering. So if I give you an example, that in the recent, in fact, only today, the illegal code on the Online Safety Act in the UK has been introduced this morning, and there are things that it absolutely prevents, but those are democratically arrived at pieces of content or kinds of behaviour that the UK government and its parliament have determined are beyond the pale. So I think that that's quite a different reason for interfering than I think the question, if your question was sort of more at the level of, do the social media companies have the right to privilege one thing over another? I think possibly they do, but not in the way that they do, because it is opaque, unclear, and in their own power.
Thank you. And I mean, to put it in my own words, what I believe you're saying, and correct me if I'm wrong, is that there is exceptions to those universal human rights that we discussed, like Article 19 of the ICCPR, for states to interfere with an individual citizen's rights under certain circumstances, but you're not aware that the social media companies have that right to interfere.
I'm sorry.
Yeah, please.
Your Honor's objection.
He was testifying. Could you rephrase your question so we...
Yeah. Okay.
So my question is, it appeared like you were, in your last answer, kind of discussing the difference between a government's responsibility versus the platform's responsibility.
Yes, absolutely. And just to be utterly clear, what I'm saying is that the right of a business to pursue a business model that interferes with a citizen's rights, or the rights as we have discussed, fails completely, in my view, the proportionality test, and the level of harm, both at an individual level and at a societal level, quite outweighs any justification for the profit motive.
Are you aware of any specific harms that have been caused by these platforms' practices, as far as the way they curate the information on their platforms?
Well, I think it's a very useful exercise to look at particular groups of people, to see the impact and the sort of the relative unfairness, i.e. it is not a level playing field. So if you look at the way that women are treated online and the freedom of a misogynistic, powerful misogynistic voice online that is unfettered. In my own world, where I know of many women politicians, both in the UK and abroad, some of them have to have 24-hour police protection. Some of them have to have protection for their children. Some of them, when the attacks came to their children, decided to quit. Academics have had to change women's studies to different courses that propose general things that don't have the word woman in. And even my own work on child safety means that I routinely have to give things to the police for my own safety. So and they are always about violence towards women and so on. And we heard from Maria Ressa earlier about female journalists. So if you can, if that is acceptable, which I'm clearly saying it is not, the impact of it is that women no longer have a voice online. Yeah? We have to get off social media. We have to get out of our public-facing roles. We have to protect ourselves and our families. And I think that that is a societal harm of such great proportion that I do not understand why that is not a political emergency.
So you obviously heard the defense's opening argument. In addition to the defense, there's many people that argue that despite these problems, social media has expanded access to information, and that its absence would actually be worse for democracy. How would you respond to that assertion?
So I think this is a completely false binary, and I did write down in the opening, in my notes, in the opening remarks of the defense, I was interested that of the language of social media concept is bad for democracy, I believe was said. And I wondered to myself at that time, what is the social media concept? What does it mean? And I think it's actually a marketing term for a particular set of businesses that are not behaving like businesses and do not have either the restrictions of other businesses. So I think, my actual answer is this is a false binary. And, human beings existed for thousands of years without social media, democracy, as we've heard, also. So social media is clearly not a necessary component. But I just don't think it's a question of whether it should exist or not exist, but how it should be designed and governed. And I really, looking back over the last 20 years, we've presided over a period in which the tech sector at large has been allowed a status, an exceptional status that takes it outside the norms of laws, rights, and democratic society. In many ways, and that exempts them from liability for their products and services. And so my question to the court, if a witness is allowed to ask a question in a sense, is to say, why is it that we are interrogating them on their own terms instead of saying, what are these companies, corporate entities, and why are they allowed to provide services and products that do not have traditional requirements against that? Product safety, and fair terms, and all the other levers of democratic society, such as competition law, tax, corporate responsibility. So I think if we think about risk to democracy, we have to first of all look at the structure of these companies and not just go right to the end and say, are they good and bad?
So are there alternative approaches, regulatory approaches that, in your opinion, would be effective?
Yeah, I mean, absolutely there are. And I sort of double down on the point I've just made and say if apps and technology companies, whatever they do, were treated as liable for the products they create, for the safety of their users, and for the societal harms, I think they would be designed very differently, and they would be designed differently to protect the value of the company because they would be liable, the liberty of their leaders because they would be liable, and obviously their reputation would be based on a different set of social and legal metrics. I think if I was to answer your question in a more sort of narrow sense, high default privacy setting, chronological feeds that are opt-in recommendation systems, clear labeling, better application of community rules, more friction to share and comment. I mean, I could go on and on and on. There are literally dozens of incremental design decisions that are based on the idea that you maximize engagement, maximize your network, and maximize the amount of time that someone spends on your platform. And if you had different, if you optimized for different reality, which was everybody getting a fair conversation and it being, having sort of, community rules where everybody got to say things and violence wasn't tolerated, et cetera, you would design each one of those things incrementally different. And just so it doesn't sound sort of, like a fantasy, I would say that when the age-appropriate design code came in 2018, we saw manifest design changes to protect the privacy of children. Dozens and dozens of them, many of them done globally. So whether it was switching off notifications at 9 p.m. for under 15-year-olds, or whether it was stopping direct messaging on TikTok, or whether it was stopping autoplay on YouTube, these things are design decisions. And so if you design it differently, it would be less toxic, but you have to decide what you're designing it for.
Thank you. So some of the regulatory control and alternative methods of design that you discussed, would they align with the UN guiding principles on business and human rights?
Absolutely.
And would they still allow the social media companies to make a profit and exist?
Absolutely.
With that, just one final question. Based on your expertise, just if you could tell the court what your conclusions are with respect to social media platforms and their impact on these human rights that we discussed, as well as any recommendations that you would make.
That was a big question. I think, let me just, say that I think that current social media design practice, and I call it design practice and corporate practice, represent a significant interference with the right to seek, receive, and impart information that is protected under human rights law. And I want to emphasize that interference is directly attributable to platform design choices, and it lacks legitimate justification under proportionality standards, and it causes substantial harm to democratic discourse, social cohesion, and individuals. And I'm sure the court will hear from many individuals in the course of its deliberations, but I do urge you to think about the fact that it has societal harms, not just individual harms, because a lot of the ideology behind the social media companies is that it is you and them, and they're not taking responsibility for their impact on the whole. And in terms of my recommendations, I really have only two. The most crucial one is that we reconsider the status of tech companies. And in particular, I would say those jurisdictions that are outside of the US might make a conscious move to release themselves from the dominance of a US or China paradigm, and rather than seeking to be a slave to the unicorns, actually develop a much more rights-based, focused information ecosystem that adhere to our obligations. So and I say that really in a context where we see a new American administration cozy up to the tech companies, or the tech companies cozy up to the new American administration, and they have a stated vision that the winners of the next revolution, the AI revolution as it's called, their vision is of the US as as the winner, and the companies as a sort of East India Company. And I think I would suggest that the judges, and I'm happy to provide it to the court, read OpenAI's submission to the US government for its AI strategy, because it focuses on US tech and it sets the rules of the road for states all over the world. So, and those rules include no regulation, free access to copyrighted material, personal data, no taxes, and a firm handle on US-based security. So I think there is a vision of theirs that this court needs to consider. And then in my second and last recommendation is in the meantime. In the meantime, we have a societal, individual, and state duty, state-by-state duty, to protect children. And I've spent a great deal of the last 12 years putting in place protections for children, and I have seen some advances, but every advance we make in one part of the world is pulled away by a tech lobby in another part of the world. And I would say that children first. We can do something now. It is a way of showing that we care. And also, if we get it right for the kids, we start to see what looks good for the rest of us. So that would be my final statement.
Thank you. I have no further questions. My colleague on the defense may have some questions, as well as the panel.
Thank you. I have about 5 minutes worth of cross-examination. Hello, Baroness.
Hello.
Thank you very much for being here. A few minutes ago, you were generous enough to shake hands with me. I told you I'm honored to make your acquaintance. We did not know each other before today, did we?
No,
You didn't.
but we both like movies and music.
Thank you. Indeed. You didn't sit for a deposition taken by me, did you?
No.
Did you receive a question from prosecution counsel asking you what dates might work on your schedule for you to be deposed by the defense?
No, I don't think I did, because I was here at the World Forum. So I was here for a particular amount of time.
And I take it then that you did not receive a question from prosecution counsel to the effect that, Baroness, we know how crowded your schedule is, but we have to respect the due process rights of the defense. Did you have such a colloquy?
I don't think I did, but I fear you feel that that something is lacking.
And so I will now switch to some answers you gave relating to the Leonard Cohen song, the Tower of Song, and I'm glad you like it. And you said that while you like it, as I remember, and please correct me if I'm wrong, the fact that under traditional media, the rich had gotten their channels in the bedrooms of the poor does not mean that this justifies going from bad to worse. Is that correct?
I did say something of that
Right.
kind, yeah.
Yes. And then you explained, as I recall, that what you mean by worse is greater concentration. Do you remember that?
Yes.
So isn't it true, Baroness, that the social media transpired alongside traditional media? Is it not?
Yes, it's increasingly interconnected, but yes.
Rupert Murdoch is still in business, correct?
Yes.
And as far as we know, this is a different entity than Mr. Musk's ex, correct?
No, I think that I'm trying to understand why you're asking as well as what you're asking. I think that, we know that many of the tech oligarchs, as we call them these days, have bought traditional media outlets. And I think we also know that the traditional or legacy media, as it's sometimes called, is now very dependent on the tech companies for its distribution. And indeed, as has come up already a couple of times, that when Mark Zuckerberg decides to downgrade news, it is his decision alone. So I think the availability of legacy media has been, and certainly the business model of legacy media, as all the advertising funds went to the tech companies, I think that the profile is completely different and the power dynamic is completely different. But I'm not sure that's why you're asking me, but I just want to be clear that I think that there has been a huge shift of power, and I think you and I may share a view on Rupert Murdoch's control of the information highway. But I would also probably say that that there is a greater concentration of attention in this new world order, where you're also doing your shopping, your communication with family, etc., as well as the news.
And so, setting aside your well-expressed views about the various interdependencies between various media, if I were to tell you that, as a matter of fact, Mr. Murdoch's News Corp does not own or control X, and does not own or control Mr. Zuckerberg's Meta, nor is it owned or controlled by them as a corporate matter, would you have any reason to disagree with those assertions?
Just who was them in the last sentence? Was that Musk or was that Rupert Murdoch?
That Mr. Murdoch's News Corp is not
owned. Yeah, no, I would agree with that.
Or controlled either by Mr. Musk's X or by Mr. Zuckerberg's Meta.
Not owned, but they have a huge influence on the outcome of his business.
Yeah. And usually the more players there are in the market, the less concentrated it is. Is that not right?
Yes.
Thank you. All right. Let's move on to a statement you made in response to a question by prosecution counsel to the effect that human beings have existed for thousands of years without social media. Do you remember that statement?
Yes.
And
Would you mind if I add something to my previous answer?
of course, please do.
I have answered accurately all your questions, but I think it may have left the impression that there are more media outlets now than there were before. But actually, in the UK alone, several hundred local newspapers have shut. That's mirrored all around the world, and the newspapers have a much lesser readership than they did. So I just don't want to leave the impression that we have more access to editorialized news. Thank you.
Thank you for that clarification. So going back to your statement that human beings have existed for thousands of years without social media, do you remember that statement?
I do.
And then you started saying democracy has existed, and then you trailed off without completing that sentence.
Would you like me to finish it?
Please.
I was indeed intimidated by your own contribution, and I was going to say many hundreds, and then I thought I better not. And so you may, since you have suggested when democracy started, I'm happy to accept your view of the matter.
Well, I apologize for any intimidation, not intended. But is it not true that democracy has not existed for millennia.
I think the point I was actually making is neither democracy nor human beings are entirely dependent on social media. And this sort of notion that gets bandied around that social media is entirely necessary is actually just simply not true. And indeed, I'd go even further and say, that social media is not necessary for communication. It's not necessary for civic action. It's not necessary, indeed, for anything that human beings have done many of these things in other ways. But my bigger point is that we don't really define social media, and whether it is good for democracy is a quite different matter.
And my last line of questioning, you were asked by prosecution counsel, and I think I quote, are there regulatory approaches that would be more effective? Do you recall that question?
Yes, I do.
And you gave very interesting answers to that question. Do you believe that this is a hearing about new laws and new policies that will be more effective for social media?
No, I am here as a witness to answer whatever question you would like to ask me. I think that the status of the tribunal is interesting, but we are all here because we are all interested. As someone, and I'm glad that you're giving me the opportunity in the final moments to say this, I am a crossbench peer, which means for those who don't understand, I am not aligned to any political party, and I definitely do not speak for the government. But I am a legislator, and I have been involved in a great deal of legislation, so it's unsurprising that some of my answers veer to what could be done rather than what the status is.
Thank you. And you do understand that this is a proceeding whose goal and objective is to apply existing law rather than creating new laws, don't you?
I think that's an interesting question, and possibly not one for me to answer, in the sense that there are some questions about whether, let's say there is an intersection between human rights and national laws and how they are implemented and how they are interpreted. And so I wouldn't say it was quite as pure as you are suggesting, in that some of the things that I see going on do not uphold existing law, and it may be that we need to be more robust about the application by reiterating our commitments through national legislation.
And very last question, since social media are on the dock here, you would agree that this is not some kind of Pirandello play, 6 characters in search of a law to convict social media on, would you? Not?
I'm not sure I have a good answer to that question. But what I would hope from the week ahead is that the impact of social media is interrogated very closely, and that the narrative of exceptionality and the narrative of it as separate, as a channel of free speech is interrogated in a way that gets under the hood of those two dominant and very healthily paid for narratives.
Baroness, I have enormous admiration for your work, especially for children, the least protected members of our communities. Thank you.
Thank you.
Please, the panel may now have a few questions. I have a couple, and the other judges may have a couple of questions, so I think we'll do that next. So you talked about media, that neither democracy nor human beings are dependent on social media. I think that was the exact phrase you used. And my question to you is, isn't social media just today's updated technological version of the public square? In other words, we've always had social media, but it started with people standing in a square. It evolved technologically to eventually radio, television, and today it's internet, electronics, and the computers and telephones we're all carrying. So when you say we're not dependent, I'm a little confused by that, because that's today's pathway, today's highway for information.
I think it's a very good question, and I think that the way I would choose to answer it is, you know, as I've said a number of times, I work very closely with a lot of young people. Since I speak on their behalf, I need to hear what they have to say. And one of the things, and it doesn't matter where in the world, by the way, not just in the UK, one of the things that they constantly talk about is the privatization of public space. That actually they used to be able to roam in the street, they used to be able to go near the shops, but actually the malls kick them out, and they don't, and the parks have been sort of closed off and built on, and so on. And the reason that I make that analogy is that's what's happened with the public square. This is not a public square in the same way, because it is organized, and in the way it is organized for a particular set of outcomes. It's not even. So the algorithms are not separate from the public square. They determine what is said, seen, and viewed.
Understood, but you wouldn't want to eliminate it, would you? Would you want to turn back progress and say this electronic digital world has to go because it has dangers?
No, but I would question that it is, technology is not automatically progress. And I think that's something that people often suggest. Technology, so for example, you know, AI can be used to measure a heartbeat of a preterm baby without putting anything heavy on its paper-thin chest. Yeah?
Yeah?
But it can also take the form of a bot that tells a 13-year-old to murder someone who's bullying them.
Well, so it's like atomic energy. It has good uses and bad uses.
Indeed. So society's job is to make sure, you know, and we wouldn't probably give Mark Zuckerberg and Elon Musk atomic energy to look after.
No, the U.S. president has that power.
Yeah, indeed. Can I just say that has its own issues? But my point being that society and collective practice and collective rules and international agreements and obligations and so on actually take a view of this. And I think what I'm arguing is we've allowed one particular ownership model to be without any of those responsibilities. And we have actually created very few levers upon which to make sure that technology is acting in a way. So now, if you see the difference on something like X from before it was bought by Elon Musk to when it's now in his care.
Well, I think we understand your answer. It's
not a public square. It's
no,
Elon Musk's square.
your answer is it's a design issue.
It's a design.
It has to exist, but it has to be redesigned.